refuse medical treatment, regardless of the wisdom or consequences of the decision. The decision does not have to be justified to anyone. In the absence of consent, any invasion of the body will be a criminal assault. The fact that the intervention is well-meaning or therapeutic makes no difference. It's very strong, isn't it? Although this case is not part of our Malaysian law, but this is a general principle that I think every legal practitioner subscribe to. You know, it is a common knowledge that anyone capable of making decisions has an absolute right to accept or refuse medical treatment. That's why we have heard of cancer patients whose prognosis is actually quite positive, but then because he or she doesn't want to undertake whatever treatment that has been suggested, nobody can force him or her. All right. And if you force it down on him or her, it may amount to a criminal assault, and that is illegal. And although mention is well-meaning or therapeutic, it makes no difference to the kid. Okay, but the issue is there are certain segments of the society who lacks the capacity to consent. Okay, so for example, and the one that is the essence of my discussion today will be children. All right, but I would also like to bring to your attention that these are the two other persons who are deemed to be lacking in capacity. There are persons with special needs. These persons with special needs can be children, can be adults, right? And they are also incompetent adults. So for this issue, what happens? Okay, now let's look at the definition of when does a person lack capacity to decide. A person lacks capacity in relation to a matter if at the material time he is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or the brain. Now, this is provided in the UK Section 2, Sub 1 of the Mental Capacity Act. Because we don't have, I feel that this definition is clear. That's why I'm sharing it as a guidance. So in Malaysia, for persons lacking the capacity to consent in all the three main categories, as I mentioned earlier, the law empowers the person having the care over such persons to authorize treatment or even vaccination. I've included vaccination here because vaccination is not considered as a treatment, but it's considered as a medical preventive intervention. Okay, so who are children? According to the United Nations Convention on the Rights of the Child, the CRC, which we have been a signatory since 1995, and the Child Act 2001, a child is anyone who has not attained the age of 18 years old. So in other words, before the eve of a person's 18th birthday, he will be considered as a child. And the implication of this is significant because as long as he is a child, all protection is afforded by the law for this category of people, regardless of religion, regardless of ethnic group, regardless of citizenship. So in other words, stateless children as well are entitled under the Child Act, and also regardless of their abilities. Now, when we discuss children in terms of medical treatment, I normally divide them into these breakdowns, okay, so that it somehow makes the discussion a little bit more clearer. So below 5, there is no question, isn't it? I mean, for below 5, clearly they lack almost total capacity to understand the consequences of whatever is been done to them. So of course, for below 5, they are considered to be, within the responsibility of their parents or guardian, legal guardian. Now, 5 to 11 years old. 5 to 11 years old, meaning 6 to 11 years old, sorry, they would have, under Islamic law, this category is considered to be mumayyiz. And also under the law, certain law, like for instance, in custody cases, 7 years old and above are considered to be having the right to express their wishes. So in other words, in custodial dispute, in where parents are divorced and they are contesting the custody of their children, if the child is 7 years old and above, the judge is obliged to consider the wishes of the child. And this is also in line with Islamic law. Okay, because 7 years is considered to be the age of discerning, mean to say the child can actually have some basic understanding and with regards to what is right or what is wrong, um, based on certain questions asked by the judge in court. So in this part, there is quite how do you put it? There is a question mark as to whether or not do they understand. Do they obviously they don't have capacity because under Malaysian law, under 18 all considered to be not having capacity. But then in terms of understanding, so 5 to 11 years old is quite a gray area. Now 12 to 17 years old, we shall this is the actually the more contentious part, isn't it? Because children in this realm of ages are normally quite competent to understand. And if given the information, given the right information and empowered with the right advice, they should be able to inform and express their wishes. But in most Commonwealth countries, this is quite a settled matter. Okay, why I say most Commonwealth countries? Because in most Commonwealth countries, they subscribe to the delegate competence rule, which I told you earlier. Okay, when I say they subscribe, meaning they share the same sources of law as England and Wales, as the UK. But for us in Malaysia, we don't follow just like that. Our courts need to adopt that law first to say that okay, we therefore adopt the Gilead principle, then it will become part of our Malaysian law. But at the moment, it is not. So at best, it is considered to be a persuasive authority. So in most other Commonwealth jurisdiction, below 16, generally they are considered to be lacking lacking in capacity, so they require parental consent. However, when they are 16 and above, the Gilead competence rule applies, meaning to say if the medical practitioner thinks that the child is competent enough to understand the implications of the treatment, then the child can actually consent to his own treatment without the bypassing the parental consent. Okay, and this would be the position in the UK at the moment. Okay, it is relatively straightforward. The responsibility to consent on treatment depends on the ability of the medical staff. Now, this is interesting, isn't it? Because this would include both doctors and dentists to decide on the capacity of those who are under 16. Because remember, the competence rule is 16 and above. So in other words, the 12 to 15 is somewhat has not been laid down clearly under the law as yet. Okay. And in the UK, whenever there is conflict, they straight away go to the court. And the court would decide on the premise of best interest of the child because this is what evidence suggests. So there are many case law in England and Wales whereby where children are 14, where children are 15, and then issue on vaccination, for example, they go to the court and the court will decide. So in other words, in the issue on the conflict on vaccination between the parents, satu parent wants immunization, the other parent refused anti-vaxxer. So the court decided that in the best interest of the child, that particular vaccination ought to be given. Okay, so the position in UK, as I've said, is actually quite straightforward. If they are unsure, they go to the court. The court will decide. But unfortunately, I cannot say the same for Malaysia because for Malaysia, the medical jurisprudence in respect to children's rights to consent somehow is really underdeveloped. And the reason for this is because people don't contest this in court. Okay, usually it is settled outside court, if they are unhappy. So just to go back again to the position in the UK, 16 to 17, because 18 is clear, isn't it? Already adult, no need to have consent. But 16 to 17 are deemed to be competent if the child has sufficient understanding and intelligence to understand fully what is proposed to them. So this is the Gilead competent rule. All right. 12 to 15, usually the practice is that they will be given the information and all that, and then the treatment will be given with the approval and support of their parents. But if the parents say no, then of course, it depends on the issue concerned. When the medical practitioner thinks that it is not such an urgent treatment, for example, then probably it will not be pushed. But if the medical practitioner thinks that, oh, without this treatment is important and all that, then probably the matter will be contested. However, I would like to bring your attention to a very recent Court of Appeal decision in England, which overturned a High Court decision in stating that parental consent is not needed for children under 16 to take puberty blockers. Okay, puberty blockers mean to say, this is on the issue on transgender. So, for instance, if somebody is born as a girl and she feels she is really a boy, and therefore, one wants to take medication in order to block the puberty by taking certain medication to stop menstruation, for instance, and all that. So, because this this medical treatment is considered to be intrusive in nature, that's why in this case, the children actually had to go to the court because the parents didn't agree. And you see, because it is below 16, right? So that's why the matter went to the court because the delayed competence would not apply to these children below 16. So they went to the court, and the Court of Appeal actually overturned. Earlier, the High Court said they have no right to take puberty blockers. So, in other words, the parents' decision, the parents' wishes override the children. But the Court of Appeal decided that, parental consent is not needed for children under 16 to take puberty blockers. For below 12, the position is clear, requires the consent from the one having parental responsibility. I see two questions in the chat. Okay.
Do you
Can
want to
I?
address it now,
Yes.
Dr.
May
Farah?
I? Yeah, may I?
Yes,
So that.
yes, please. Yes,
Oh,
please.
okay. Let me just look. Okay. Um. Okay. Thank you so much. Okay. First question. I would just like to clarify that the link endorsed by government body, is it secondary source? Um. That's why it is both a secondary. It is both a secondary source, and it comes also uh under others. Remember my third category just now in my chart, it comes under others. Because although strictly speaking, it is not in court of law, it may not be something that is higher than the primary sources, but because we are penjawat awam, we are civil service, we are bound by that perkeliling. So like I say again, if you do not respect the perkeliling, you may get into trouble professionally. Okay. Another interesting question is that how many legal guardians can a child have? Divorced parents who then remarry result in two sets of parents. Are the step parents considered the legal guardians when the biological parents are alive? I would say no, because legally speaking, the biological parents would override the step parents. Okay, unless the court has decided otherwise. You see, naturally, it is of course the biological parents. But then of course, this is what we have about custodial disputes, isn't it? Sometimes only one parent has got the custody over that particular child. So in most matters, that particular parent who has that full custody would have the authority. But under our Guardianship of Infants Act, most parents share equal guardianship of the child. So, but then it doesn't say step parents, unless that step parents has been designated by the court to be the legal guardian as well. I hope that answers the question. Okay, next slide. Now let's look at the sources of law in respect to children in Malaysia. Okay, so Child Act 2001 is of course the most comprehensive act relating to children. It is actually not a new law if you ask me, because this act actually consolidated in 2001. This act consolidated, menggabungkan three previous acts. It consolidated the Juvenile Courts Act 1947. So we used to have a law separate for children who offend, children who commit crimes, and children who are beyond control. So it used to be in a separate act called Juvenile Courts Act 1947, which also established the Juvenile Court. And then the second act that was consolidated was the Child Protection Act 1991. Now this act is purely for the protection of children. Uh, in children who need protection and care. So the ambit is very wide. So it includes children subjected to child abuse and neglect, children needing medical treatment, children abandoned, children neglected, and the other third act is Women and Girls Protection Act 1973. Now, this is the act to protect girls and women who were subjected to sexual vices like prostitution, etc. So, in 2001, these three former acts were consolidated into one comprehensive act called Child Act 2001. Now, the wonderful thing about this new act is that it no longer discriminates between gender, because as you could see in the Women and Girls Protection Act, it's only for girls. So, what if boys are exposed to the sexual vices, as what statistics have shown us? So, because of that, it no longer discriminates. It applies to children regardless of their gender. This Child Act is both protective and punitive in nature. Why I say it is punitive? Because it creates various offences in respect to acts which are unacceptable towards children. For example, child abuse and neglect section 31 will impose punishment up to 20 years imprisonment or fine of 50,000 ringgit. It also creates the offence of leaving child without reasonable supervision, section 33. So basically, it is an offence, to leave your child at home, like latchkey children, panaskan lauk sendiri, look after the younger children and all that. Uh, Strictly speaking, if you go by the law, that is not allowed, because you cannot leave children without reasonable supervision. Of course, what amounts to reasonable or not, we don't have yet a case law to decide what amounts to reasonable and what is unreasonable. And but most of all, I feel that the Child Act is more protective in nature, despite having this several provisions on creating offences against children. It is more protective because it provides for many sections empowering the authorities, people like the medical practitioners, people like the social welfare officers, people like the police officer, to intervene whenever a children's life or children's best interest is compromised. Okay, so the Child Act is a powerful tool to protect children, provided people know about it. Okay, the other protective act is the Domestic Violence Act, 1994. Now, this act protects anybody in the domestic realm from any form of violence, and this is not the forum to be discussing domestic violence, but this is the act to protect anybody within the same household. So there are the lima category. It protects spouses from each other. It protects ex-spouses, ex-wives or ex-husband harassing their exes. It protects the elderly in the family. It protects the children, and it protects any other member in the household which are subjected to any form of violence. And the violence are actually wide ranging. It is physical, it is emotional, it is threats, it is cyber threats, cyber violence as well. They are all included. Now, penal code, we all are so familiar. Almost every day, isn't it? We hear kat social media, kanon kesiksaan. Memang siksa, because it provides all punishment for, I think, any offences under the sun. So, of course, the penal code is wholly punitive in nature. Now, a more relatively new act is the Sexual Offences Against Children Act 2017. Now, this is both also like the Child Act, punitive and protective act, because it creates three distinct category of offences in relation to sexual abuse. So, for instance, to groom a child sexually is an offence. To sexually assault a child, whether physical or otherwise, is a sexual offence. To be involved in child pornography is a sexual offence. So it is very punitive in nature. Okay, it if you ask me, it leaves it's quite dangerous, because even people, innocent people like us, also may be guilty uh if we had accidentally downloaded, for example, pornographic material and then forgot to delete it, and then suddenly it is found in your laptop. But of course lah, luckily our authorities are not that robust, so many people escape from that. Okay, and it is protective because it relaxes a lot of the procedural and evidential requirements for children as witnesses in court and the requirement of evidence. And finally, we have the Evidence of Child Witness Act 2007. This is protective because it assists children on being witness in court. Now that is an overview. Okay, so now you are most welcome to have my slides after this. Okay. I was requested to add a little bit about vaccine. So I'm going to share about vaccine against treatment versus treatment. Okay. Now the biggest difference between a vaccine and a treatment is that one is designed to prevent, while the other is designed to treat or to cure. Both, however, would be beneficial when it comes to preventing and managing COVID-19. Okay, because this is the issue, and you can ignore these slides because this one is actually an example of what amounts to um, incapacitated adult. Okay, these are the examples. So I did not delete this slide because I feel that it may be useful. This is some guidance. Now, issues on consent. Sorry, this slide is not supposed to be here. Can I just come back to this slide later?
Yes,
Sorry,
sure.
sorry. Okay. Um. So, in regards to the COVID-19 vaccine, yeah, the consent is actually provided in the clinical guidelines on COVID-19 vaccination for adolescents 12 to 17, and the provision is this. Um, Section 9 provides information regarding the vaccine's efficacy, safety, and possible adverse reactions should be clearly explained to the adolescents and to their parents or caregivers prior to the vaccination. Parents or caregivers will be required to sign the informed consent form on behalf of the adolescent. So, in other words, looking at this, it would appear that it would be very difficult, isn't it? Let's say a 17-year-old wants to be vaccinated and the parents refuse to allow consent. This is the issue that I see from this provision because there is a requirement that the parent has to sign the informed consent form. Okay, informed consent do matter, but so does protecting people from infectious diseases. Um, I would like to show you a comparison that I made with the pre-COVID-19 pandemic situations on vaccine refusal. Now, in Malaysia, we have developed by leaps and bounds in terms of our immunization programs that we had successfully reduced the number of infant deaths by 85% from 1970 to 2017, from 55.9 deaths for every 1,000 live births to only 8.4 deaths for every 1,000 live births. And statistics, however, by Malaysian MOH documented vaccine refusal has been on an upward trajectory between 2013 and 2016. And this increase in vaccine refusal did not happen in isolation because as a result, the number of cases for diseases that can be prevented by vaccines has also swelled in recent years. So, for instance, I'm just quoting measles. Yeah, there are also other statistics for diphtheria, polio. So, for measles, for instance, there were 1,934 cases in 2018 compared to merely 195 in 2013. So these are the situations lah. Kami takut vaksin, there was in the newspaper anak pelakon buat laporan polis tolak vaksin. And however, the Ministry of Education do not discriminate. Children who are not vaccinated will be allowed to go to school. All right. So how is it to make autonomous decisions? It must be based on full, accessible information enriched without coercion. The information provided must address the nature of the procedure, including benefits to the child, benefits to society, and the risk. Parents should have their concerns and misconceptions addressed. The information needs to be accessible and include an opportunity to ask questions. So I think this is where we have to have a change of approach. Many times people think, oh, because in Malaysia a parent's consent is required at all times, we forget about the child. It is always good practice to respect the wishes of the child. So I would strongly advocate that before we indulge in any treatment with the child, no matter how minor or major it is, inform the child and come to the decision which is agreed by all the three parties, meaning the medical practitioner, the parent, and the child. Now, allow me to go back to my slide which I missed. Okay. Now, on consent, there are few issues that that relate to pediatric treatments of pediatric patients. Yeah. So I think in terms of general treatment, I have dealt with what is in the position in the UK and what is the current position in Malaysia. Now, these are some of the questions posed to me. Quite common issues. Yeah. What about consent for publication in social media? Oh, definitely this one you need consent. Okay, because this is basically in protecting the right of privacy to the child. Consent for physical restraint for uncooperative patients. Now, if the patient is, of course, underage, or even I think if the patient is lacking in capacity, people, like patients yang I think my second category earlier, incapacitated adult. Mean to say, they don't have the mental capacity to actually understand fully. I'm talking about people who have special needs, and they can be children, and they can be adults. So in this situation, you need to impose physical restraint. Therefore, the next person who have the authority should consent to it. For instance, I remember when my special son, he's born with Down syndrome. When he had his first dental treatment, he was brought to the pediatric dentist in HKL, and the clinic was so nice. It's so child friendly, and the dentist and the nurses also were wearing colorful uniforms. Um, and overalls. But unfortunately, my Ahmad then, who was only 7 years old, didn't understand, and he had three wishes to be extracted. So of course, some restraint was done in the form of, they sedated him basically with our consent. Okay, consent for clinical photos is also the same. Anything that is done involving the patient requires prior consent. And non-accidental injury, okay, now this is more interesting. For non-accidental injury, anything that is non-accidental in nature, of course, is protected. Okay, but the thing is, if it is brought to court, naturally not on a criminal action, but on a civil action, then of course, whether or not it amounts to accident or not will be dependent on the facts of the case. So there, it is very much dependent whether sufficient care has been taken. But generally speaking, non-accidental issues should not give rise to legal consequences unless, the consequence is really dire, and therefore, the other party will want to claim for damages in order to compensate the situation. Um, in Malaysia, all right, the general rule is all below 18 requires parental consent. What if there is a conflict? Um, it is actually very hard to say because we do have several provisions in the Child Act, which talks about a child. Section 17, for example, defines children in need of protection and care to include children who needs to be examined, investigated, or treated for the purpose of restoring or preserving his health, and his parent or guardian refuses or neglects to have him so examined, investigated, or treated. Now, this definition of children in need of protection and care is very important because in the various categories of Section 17, what happens is that if the child comes under this category, then intervention can come in. You see, so this is the section that defines child abuse, children in need of protection and care because of being exposed to abuse, for example. Okay, so section 24, subsection 3, following from section 17, further provides um, parental consent can be bypassed if parents has unreasonably refused to give or abstain to give such consent. But it has to be in treatment which are regarded to be serious in nature. But in this situation, what the medical officer needs to do is to certify it in writing, and the authorization must be given by the protector, who is the social welfare department, basically a JKM officer who is gazetted as a protector. So in other words, the medical practitioner cannot act alone. The medical practitioner has to obtain authorization, and coupled with that authorization can actually bypass parental consent. Okay, and the question about what if there is a negative consequence? What if there is injury? What if adverse consequence result from that treatment which did not have the consent prior beforehand? Section 26 provides there is no liability incurred for giving authorization and for everybody who is involved in the situation. And Section 26 actually lists down medical practitioners as well. And if that is not enough, Section 123 of the Child Act provides protection against suit and legal proceedings. Suit, of course, governs civil suits, and legal proceedings would be any criminal action. No action or prosecution shall be brought against the government, the minister, the DG, protector, social welfare officer, probation officer, police officer, or medical officer for anything done or omitted to be done under this act if done in good faith. So the prerequisite is anything that's done is done in good faith in the reasonable belief that it was necessary for the purpose intended to be served and for carrying out the provisions of this act. So wherever I go, whenever I talk to medical practitioners, this would be, these 4 sections I will always emphasize. Okay. So I'm going straight now. Before I end, I believe I don't have, yes, I believe we only have 10 minutes. I want to end with Article 24 of the CRC. The CRC recognizes that without good health, children have little hope of fulfilling their potential. So we are obliged to uphold this. We must recognize the right of the child to the enjoyment of the highest attainable standard of health and to facilities for the treatment of illness and rehabilitation of health. Because of that, state parties shall strive to ensure that no child is deprived of his or her right of access to such healthcare services. Thank you very much.
Thank, thank you so much, Dr. Farah, for your very interesting and informative lecture. Actually, we have few questions here, Dr. Farah. It's
I'm
from
looking at them now.
from Dr. Farah Elani. It's about the a letter of oath of guardianship. Is the letter acceptable for us to carry out procedure? Can it be used for invasive procedures?
Yes, some of the guardian presented to us a letter of oath of guardianship. This is letter Waalaikumsalam, Dr. Farah. To be honest, this is the first time I'm hearing of it. I'm so sorry. Due to my lack of knowledge on this is the first time I'm hearing this letter of oath of guardianship. I have to get back to you on this. But I believe that any form of a legal document should be acceptable. But unfortunately, I cannot vouch on it because I don't have a definitive knowledge on this. I need to check with with my fellow colleague who is the real expert of the medical law. Whether, letter of oath of guardianship, it will be acceptable. I would imagine that I would think so if the person does not have actual legal guardian. So therefore, this is the proof of that legal guardianship, if you get what I mean. Okay. And if it can be used, then of course it can be used for anything, including invasive procedure. But allow me to get back to Dr. Nabihah or Dr. Faisal on this. I will check on it, and then so that the answer can be in the affirmative. Okay. I have a unique situation. Let's say a child that is in need of a procedure that requires to, I think this is quite common, isn't it, for dentist, right? GA. The child in question has special needs. Yelah, lah, macam Ahmad hari tu lah. Tapi Ahmad was only sedated. Dia bukan under GA pun. They sedated him. And is also born to parents that are both having intellectual disability. Whom will I need to ask for informed consent for the procedure that this patient need? Okay, thank you so much. I think this one I do have an answer. I think for this particular purpose, you can contact the social welfare department. Sebab memang definition for children in need protection pun macam the parents tu macam unable, bukan dia tak boleh bagi, kan dia unable kan. Dia bukan abstain, dia unable to give consent. So kalau macam tu, I think I think you should contact this because they are the gazetted protector. So in any issue under the Child Act, when the parents cannot do anything, they are the ones who come, who come to actually in the place of the parent. All right. So
there's another question. Farah from Dr. Farah Ilani again is about the written consent. Is it necessary for radiograph and blood investigation?
written consent. Now we were debating this as well last Saturday. We were having that COVID punya discussion. When you talk about consent, the consent is actually immaterial, sama ada dia written or oral. Okay, but
Yeah.
I always advise doctors and dentists as much as possible try to have it in written form. Sebab to save you, not for anything. Cuma the difficulty is that sometimes I know in the heat of in the urgency of the situation tu kan susah. That's why kalau boleh lah kan get the protector to cover you if possible.
But for radiograph and blood investigation is part of the investigation, Dr. Farah. Is it
Kan, dia
necessary?
bukan
Yeah, it's
treatment
not
kan,
a
that's why.
treatment.
Yeah,
I'm
it's
not
not
sure whether.
treatment, that's right. So probably no, and probably if it's the result from, let's say, the previous procedure which you have already gotten consent. Contohnya selalunya kan kadang anak-anak kita dentist, anak kita masuk sekolah, we have to sign that blanket approval or rather blanket consent, right? So maybe that can come under that as well.
Yeah, just I think all this while we're not practicing of getting written consent for radiograph and blood investigation. It's more to verbal,
Investigation.
inform and verbal consent. So that's why Dr. Farah just want to know, is it necessary to get there?
Yes, I personally don't think so. Although I would think that ensure that you have some form of. It'll be good, to actually have a form. Just a form ready, like the duty of doctor to inform if suspicion of abuse and neglect as well. So now hospitals have got a form 27, I think. So if you have a form, it is much easier, isn't it? Because then it can bypass any potential. Although I always say that Malaysians are less contentious, you never know.
Yeah.
Even though the society develop, people may become more contentious in the future. So it is better to actually cover yourself.
All right. Let me check in the YouTube. Is there any question in the YouTube? Let me check. I think there's no question because the participants also can view this live webinar through the YouTube channel. Yeah. There's another one from Dr. Tan. Dr. Farah.
Okay. May I know if the handwriting in the written consent form, sometimes we will fill up the details like I don't under the handwriting in the no, I don't think so. As long as it is written and it is signed, it should be fine. It doesn't matter whether it's typed.
Whether it can be read or not.
That one masalah sikit lah kan. Yeah, that one. But I think in law, it doesn't say that anything must be typed out. No, it can be in written form, handwritten form. The worry is only when if that document is contested in court and that handwriting give rise to a variety of interpretation. Itu je lah yang I nampak isu dalam mahkamah. Bila benda tu tulisan tangan, lepas tu nanti defense counsel pergi interpret lain, prosecution pergi interpret lain, that's when the issue comes in. So itu sebabnya I think most medical reports now are done by typing. Tapi that does not mean that a handwritten form is unacceptable, is invalid. It is still valid document because yang penting tu is the information there and the signature. It's the signature.
Yeah. Let me check again. I think you have answered all the questions, Dr. Farah.
Dr. Farah, can I ask one question, Doctor?
Sure, Doctor.
Yeah, just now you mentioned that the interpretation too, let's say we wrote like a sentence, kan? What we meant sometimes when people read, it is they interpret differently. So who has the final say of what the interpretation of that sentence is?
Mahkamah lah. No lah, I'm just kidding. I mean, ultimately, anything, of course, the court will be the decider, right? But the court in deciding also will also based on conventions. For example, doctors, dentists, you have a certain way. You have your lingo in saying things, isn't it? Like we lawyers as well. We have our own style of saying certain things which lay people may not understand. So for example, you say things, evidence speaks by itself. I will say res ipsa loquitur. Tapi the courts kan bila dia do interpretation, dia akan lihat kepada conventions. Convention bermaksud apa yang menjadi amalan. So kalaulah ayat tersebut memang secara amalan merupakan rujukan kepada sesuatu perkara, Then mahkamah akan interpret it in such a way. Sorry lah ya.
Oh,
Nampak
lupa.
pula dah bahasa
No worries. Is there any other question from the participants? You want to, you can unmute yourself and ask verbally to Dr. Farah.
Yeah, by all means.
Minta maaf Dr. saya makan sambil dengar.
Tak apa, I know it's
Please, please.
lunchtime anyway. I'm eating after this. Before my lecture pukul 3. No problem.
Yeah.
I'm
I
so sorry
think-
if the lecture does not cover everything on the legal issues. Actually banyak nak discuss kan.
No, it's very
Daripada
informative
saman.
one.
Yeah, but then I think I just want to give an overview because especially my first 2-3 slides tu kan, kadang-kadang we go straight into guidelines. Apa position guidelines sebenarnya, you know, so that's why I want everybody to understand what are primary sources in law. Primary sources memang binding. Secondary sources tak binding. Tapi digunakan dalam mahkamah untuk mendorong hakim untuk mencapai satu takrifan yang memihak kepada kita. See? Itu maksud dia persuasive authority. Tapi hakim tak boleh kata, oh we are bound by the CRC. Tak boleh. Sebab kita tak bound. Kita state party. Kita jadi state party. Morally we are bound. That's why kita treat our children better semua. Tetapi selagi mana kita tak ambil peruntukan tu jadi part of Child Act contohnya, dia tak menjadi undang-undang. Macam tu juga Gilead Competence Rule. Secara prinsipnya memang bagus keputusan tu, isn't it? Kita respect the opinion of the child. Tetapi tak ada mahkamah lagi di mana in any case kata, okay, we adopt the Gilead Competence Rule. The reason tak ada case is because orang pun tak contest kat court lah. Kan? Cuba ada, let's say, a 16, 17-year-old minta contraceptive pill contohnya. Lepas tu parents disagree. Tapi kita, budaya kita ni agak lembut sikit lah benda-benda macam ni. Belum sampai nak lawan kat mahkamah lagi kan. So that's why kita tak ada case law. Itulah dia, that is the limitation lah. Bila kita tak ada case dibawa ke mahkamah, kita tak adalah case law yang primary source yang kat atas tadi tu.
Yeah, usually the Malaysian culture is more to accepting.
Yes, rebel. Rebel dalam ketidakpuas hati.
Pasrah, yes. Rather than questioning or, want to get the answer. Dr. Farah, if you don't mind, maybe we can email you if we have any question regards to the legal issue.
Email boleh, tapi you tahulah kan, Dr. Nabihah.
Yeah, we know that.
Boleh, tapi whether I reply properly or not is another issue. Kalau time I memang depan tu, I boleh answer 5 emails at the same time. Time I tengah prepare for 3 presentation in a day, memang boleh lah.
We totally understand that.
No, it's okay. No, I welcome if you have any issue at all. I don't guarantee I have all the answers, to be honest, you know, because medical law is not essentially my area. My area is criminal justice and child rights.
Okay.
But of course, children do relate to many issues in medical. So that is how I get embroiled in medical as well. But I can always check with my colleagues who have more knowledge in these areas, and inshallah can share with all of you.
All right. Dr. Farah, I think we have come to the end of this webinar, and I'm sure all the participants have learned a lot from you today. So on behalf of the organizing committee, I would like to thank you again for taking your time out of a busy schedule to be with us today. Okay, to all participants, don't forget to fill in a form for your certificate, and please visit our YouTube channel, MAPD 2021, and you can watch this webinar again at a later time or share it with someone who might be interested. Okay, thank you for your attention and see you in next webinar session. Thank you, Dr. Farah.
Welcome. Nak leave. How to leave? Okay.